Good evening, this is John Milburn for Laws 11062, Contract B. We're into week 9. We're still dealing with week 8 material, I believe, maybe even week 7. So we're dealing with repudiation, termination. I think that's week 7. We'll move into frustration tonight and eventually we'll catch up. For those of you that have joined me this evening, thank you very much. I suspect that you're amongst the fairly considerable cohort that had uploaded their assessment by mid-afternoon this week's or today. So thank you very much for doing so. And I hope that by getting your assessment in and done quickly, it provides you with an opportunity to prepare well for the examination. Now, in terms of feedback, as you might expect, this particular assessment takes some time to finalise. So the cutoff is Saturday week. That's when I'll stop receiving assessments, and I hope to have everyone's assessment feedback back to them by Sunday of next week, so Sunday week, so about 10 days from now. And I have started the process. I've looked at some, and overall the work seems to be pretty good. If you haven't completed the work yet, hopefully you'll be able to complete that tonight. And if not, remember you lose 5% per day for every day of late submission, but do remember the cutoff. I won't accept any work after that time. Now, last week we were talking about some concepts around repudiation primarily, and you'll recall that the doctrine of repudiation allows an innocent party to terminate, which is another specific word that we use in contract, to terminate a contract as soon as it becomes apparent of one basic element, and that is if the other party is or represents that they're going to be unready, unwilling, or unable to complete their obligations in the contract. And we usually refer to that in the opposite manner, meaning that a client or a party wants to establish that they are ready, willing, and able to complete their obligations under a party. So if a party is no longer ready, if they're no longer willing, or they're no longer able, then it's open for the innocent party to say, you have repudiated your obligations under the contract. And of course, the innocent party has two basic alternatives: either accept the repudiation and terminate, or continue with the contract, which is affirmation, and leave available to them the ability to sue for any resulting breaches. But you need to make it clear. So some simple examples that you've read about presumably is, one is Rochester and de la Tour. It's a very old case, 3-month tour of Europe. Before he departed, de la Tour informed that he'd changed his mind, no longer wanted to employ Rochester in that capacity. Rochester sued and won on the basis that de la Tour had repudiated the contract. In other words, de la Tour made it clear he's no longer willing to complete his obligations under the contract. So that's a very simple example of what we mean by repudiation and the ability of another party to either affirm or terminate, and then to do so. Now, repudiation can be by words, as it was in that case, or it can be by conduct. And here's where we need to consider the objective test. So always, whether a contract has been repudiated or not depends on the facts. And there are categories of conduct that might give rise to a claim for repudiation. So an example is express refusal. It's very simple. So a party simply declares, I'm no longer ready, willing, and able, or any of those, to complete the contract. Rochester and de la Tour is a great example. But the repudiation by words commonly occur where a party finds that they're not able to complete their obligations, and there's those grey areas of, well, what if they can complete but not on time, or not completely, or not exactly as per the contract, or a mixture of those things. So cases tend to be around those sorts of issues. We don't seem to get the very straightforward Rochester and de la Tour type situations reaching the courts now. So an example of where it starts to become grey is a High Court decision of Foreign and Wright, 168 CLR 385 from 1989. And this related to conveyancing. The seller of a property couldn't provide clear title. the property was subject to an easement. He couldn't remove it, at least in time, and the purchaser might have allowed more time with some damages for the delay, but decided to treat the contract as repudiated and terminated. So essentially, the seller could still provide the property. Everything else was still the same, but it had this encumbrance, this easement, and it entitled the buyer in that instance to terminate the contract. Now, when you're looking at these questions, I'd like you to think in terms of a few basic issues, and one of them is whether time is of the essence. So I mentioned this grey area of whether someone can complete, but maybe not on time. And if you're thinking about these issues around the time for performance and whether time is of the essence, can anyone think of, and I know it's only a small group, so I won't pick on you too much, but can anyone think of any areas of law that they might need to consider? Conveyancing is a very good specific area of law. Time of the essence is critically important. But even more general than that, are there any general sources of law that may have a bearing on the question of whether time is of the essence in relation to this matter? Statute barred? That's actually a really good comment. It's not the one I had in mind, but it's a very good comment. I appreciate that because it's something you should always think about. It should be part of your toolkit deliberations. Now, I know I'm being a bit abstract in my question as to what type of broad area of law, but I'll mention what I've got in mind. Basically, areas relating to primary sources of law on the one hand, and laws determined by reference to the contract between the parties. And the primary sources of the law that you might need to consider when determining a question of this type relates to the common law, it relates to equity and equitable principles, and of course it relates to statute. And very often, if you're answering a problem around this area of practice, or indeed in your entire degree, you may need to bring in elements of common law or equity or statute or arguments around each of those areas or some of those areas. So there, if you like, I'm calling them the primary sources of law, as opposed to the contract that was signed between the parties. Now, Natalie mentioned conveyancing as a key area, and the reason that time is of the essence in relation to conveyancing matters is pretty simple, because the contract provides the time will be of the essence in relation to the aspects of the agreement between the parties. So that's why it's there, and that's why it has force. But if we didn't have that contractual term, then we need to consider the common law, equity and statute and try and find an answer there. It's a mistake to immediately launch into an argument about those areas but without first considering what is in the contract. And when I was if you like, supervising solicitor in conveyancing areas, this is some time ago, conveyancing clerks would come to me and say, we've got a problem. I'm not sure what the answer is. Where should I look? The answer almost invariably was, look carefully at the contract, look at the special conditions, look at the standard conditions, and you'll find the answer there. So I'd make them go and have a look at that and then say, come back to me once you think you found the answer, then I'll cross-reference it. So the contract's very important. But if we take that out for the moment and we think in general terms, then the common law rule was that time is of the essence. So at common law, time is of the essence unless the parties had expressly stated to the contrary. Now, as you might expect, equity is entirely different. And equity drew a distinction between form and substance and adopted a rule that performance on time was not essential if the substance of the contract could be carried out and the promisee could be adequately compensated for the loss or damage as a result of the slow progress. So equity took a much more robust approach to the harsh rules of common law. An example of that is Nita Epping, PTY and against Phillips, 1974 131 CLR 286. Now, there are some statutory rules. For example, in Queensland, the Property Law Act, Section 62, provides that the equitable interpretation is to be favoured as opposed to the common law rules. So the statutory provision doesn't alter the legal construction of the contract. It just says in general terms, equity prevails, which we probably didn't need that statute because that's a general principle of law, but it's there in Section 62. Another good example, if you want to look at these areas, is Perry, P-E-R-R-I, against Coolangatta Investments, 1982, 149 CLR at 537. All right, so we're talking about this area within the context of express repudiation. The second area where there may be an argument around repudiation is if there's a repudiation by implication. Now we're becoming even more grey in the areas. We're getting a long way from Hochester and De La Tour now because one of the parties is arguing that they have the entitlement to terminate the contract based on the other party's repudiation. And when challenged, they say, well, by implication, you have repudiated the contract. It's not stated expressly, but it's something that the innocent party implies from the conduct of the other party. Good example, Hammer and Barrow against Coca-Cola, 1962, New Zealand Law Reports 723. Coca-Cola, I don't know, I'm of an age where I remember the Coca-Cola yo-yos. And Coca-Cola in New Zealand ordered a whole bunch of these yo-yos from Hammer and Barrow, 200,000 of them. The first batch, 85,000, and 80% of them was defective. They were returned and Coca-Cola terminated for repudiation, basically saying, based on what we've seen in the first batch, Hammer and Barrow, even though you're not saying it, by implication, we're saying that you're not ready, you're not willing, and basically, more particularly, you're not able to perform the contract. So we're repudiating. Now, as you might expect, inferring repudiation is tricky business. This is where we get into legal arguments. I mean, for example, 80% you might say, well, that's fairly clear. But what if the failure rate was 20%? What if it was 10%? When does the failure rate become so high that Coca-Cola could infer repudiation? And the answer is, it's not written down anywhere. And that's where lawyers have to make an informed guess and clients need to punt in the courts as to whether they're going to be successful or not. Now, but when there is an implication of repudiation, the innocent party, as always, needs to state clearly what the election is, and they need to call what is the repudiation. An example to look at, Lorinda Proprietary Limited against Capalaba Park Shopping Centre. It's in the material, I think. It's a very important case to do with leasing and conveyancing, but here there was a substantial delay in performance, and it comes back to that time of the essence element and implication. So it really is difficult sometimes to determine these facts, and you need to consider it. And there are different standards that apply in terms of one standard is strict liability. There has to be exact performance. The other is where there's a duty to require that requires some care or diligence. By that I mean this, when you look at the facts, it may be, let's say go back to the Coca-Cola case, if instead of delivering yo-yos, Barrow and Hammer and Barrow had delivered something entirely different to yo-yos, then really it's a very strict liability. But when it's to exercise degree of care and diligence, it's a little more difficult to tell. So how can you tell? Now, the standard of duty applicable to contractual obligations depends on the construction of the contract. And you'll hear that phrase often, the construction of the contract. That's lawyer talk for how do we interpret this contract? How do we piece it together and unravel it? That's the construction of it. So a party may need to exercise reasonable care, or in the contract it may say that a party is to use its best endeavours. So if you see that type of framework, that type of wording, then it's not likely to be a standard of absolute or strict liability you're talking about. It's more one where the some degree of care or duty or diligence is required. Now that's repudiation by implication. Another type of repudiation is repudiation by erroneous interpretation. A party might repudiate because they don't at law understand the contract, or they misinterpret the contract, and that can happen. So Luna Park and Tramways advertising was an example of that. Tramways thought it was correctly performing its under the obligations by advertising on the trams for an average of 8 hours per day. It was unwilling to carry out its obligations under the contract to have it at least 8 hours per day. Luna Park declared that they had repudiated and enabling it to terminate the contract. Now, another area of repudiation, and this is a really interesting area, is repudiation by wrongful termination. This is where it gets really interesting. I talked about this briefly last week. It's where we have the situation where one party says, you've repudiated the contract, we're terminating. The other party says, no, you were wrong to regard our actions as a repudiation, but we regard your purported and wrongful termination as a repudiation, so we're now terminating. And you have both arguments, you have both parties basically arguing the same thing. You've repudiated, we're entitled to terminate, and it's a cross application. So wrongful termination occurs where a party incorrectly believes they have the right to terminate the contract and they purport to do so. Now, there may be a guilty party. The guilty party may have breached the contract. The question is, have they done so in such a way as to justify the innocent party terminating the contract? If the innocent party gets it wrong, they then become the guilty party by wrongfully terminating the contract based on an inadequate repudiation by the other side. I know that's a lot of words. I hope it's making sense. The key for this is to flesh it out in wording that makes sense to you, have some cases that support an argument, and then you can argue either way because there's not necessarily going to be a right or wrong answer. Now, a good case to look at by way of an example is Commonwealth and Amman Aviation. We've looked at this case a few times. And you might remember that Amman Aviation was unable to provide aircraft required for customs duties within timeframes that were set out in a contract. The Commonwealth sought to terminate the contract, but failed to show or follow the process in the contract. The Commonwealth then had improperly terminated the contract. In effect, as a result of improperly terminating the contract, the court held that they had in fact repudiated, and therefore Amman Aviation was itself entitled to end the contract and sue the Commonwealth for damages. One thing you may have picked up on this is this, and it's a rookie error, but there's no automatic termination. So no matter how serious a breach of contract, that does not, in the absence of an express clause to the contrary, have the effect at law of automatically terminating performance of the contract. So the rule against automatic termination applies where there's a breach giving rise to a right to terminate, then termination is a matter of election on behalf of the other side, which means that the innocent party can either terminate or affirm the contract. I know I'm repeating this to some degree, but it is a rookie error. People simply say, you've breached the contract and therefore the contract is terminated. It doesn't work like that. Now, another area is repudiation by inability to perform. And this occurs either by express words or acts, for example, foreign and right that we talked about earlier. If the inability is implied, it must be shown that the party is wholly or finally disabled from performing, or there's been a substantial inability to perform. And another area that we talk about in this area of law is anticipatory breach. We mentioned that earlier. It's a form of repudiation, isn't it? Anticipatory breach. It's where a party is not actually yet in breach, but the circumstances make it clear a breach is inevitable. In which case, when it becomes clear that it's inevitable that one of the parties will breach the contract, the innocent party can terminate immediately based on the anticipatory breach and sue on the basis of that, or else they can wait till the breach actually occurs and then sue on that one as well. All right. All good so far? Are there any questions, comments? No? All right. And just going back to the hammer and barrow situation, Stephen, some good comments there. It depends on the context of the product. If it was for vehicles, 20% would be large, but 20% of cheap yo-yos would be considered differently. That's an excellent point, and it goes to the objective nature of the arguments, and fundamentally every case is different. I like your argument there. I'll just make a final comment on this area. It's dealing with the treatment of discharge of contract. There are three bases for discharge under a contract. One is by agreement, one is by exercising an express or an implied right of termination, and the third is discharge by frustration. Now, this one might be automatic, unlike termination that we talked about earlier. And that is my lead in then to the week 8 content, which is frustration. Now, hopefully you've all read the material relevant to frustration. And I think from memory, when I last took this unit, the final problem that I set for students was around this issue of frustration. So it's an important area, and COVID-19 has highlighted the importance of these areas of practice. So what is frustration? Well, the first thing is it's a legal term that has a specific legal meaning, and that legal meaning is really quite different to the everyday meaning of frustration. And it's one of those examples where a legal term means something at law, and you recall basic principles of statutory interpretation, that where a word has a technical meaning, then in a statute, then it's the technical meaning that is implied to be what was meant by Parliament. So when an unexpected event occurs and it fundamentally or radically affects the performance of the contract or the benefits the parties would reasonably anticipate from that performance, then the doctrine of frustration applies to automatically terminate the contract. There's a lot of concepts there, and one that really stands out is, despite what I was saying about repudiation not affecting an automatic termination, the opposite applies for frustration, where the frustrating event operates at law to automatically terminate. The authority for that proposition, and the case that you should probably look at right away if you're dealing with a frustration problem, is Codelpha Construction, Proprietary Limited against State Rail Authority of New South Wales. It's High Court. Many of these cases are High Court. 1982 149 CLR 337. So Codelpha tells us some of the basic rules around frustration of contract. the event must occur after the contract is made. That's one thing. Number two, it must make the event impossible. Number three, it may have the effect of making performance impossible. For example, if a party dies, the subject matter of the contract is destroyed, or there's a substantial delay in performance, or performance renders something illegal or financially burdensome. So a lot of grey areas there, but a contract is not frustrated by an event that is attributable to the fault of one party. So there's a huge rider there. And that is one of the reasons why many cases that look like they're frustration cases are not in fact frustration cases, because arguably one of the parties is at fault. Also, a contract is not frustrated by a foreseeable event where the parties must have implicitly expected or at least assumed some risk in relation to that foreseeable risk. So that's the basic introduction to frustration. Comments from Natalie, with COVID, it's a very grey area. I agree with that. And while with no certainty regarding COVID, it's very hard regarding frustration in terms of the COVID, is it temporary or is it permanent? I'm not sure I've got answers to that, Natalie, and I think but it's a very good point to raise. And it's one that is being considered very often. Now, this is frustration, and the common law recognises frustration, but it doesn't recognise any doctrine of force majeure. Now, they're related topics, but they are different. So we see force majeure clauses in some contracts, and if you see something that looks like a frustration clause in a contract, it's really a force majeure clause, and it's where the party seeking to rely on the clause bears the burden of proving that the occurrence of the event was contemplated within the clause. Now, for example, if we have an unexpected event such as war or crime or an earthquake that prevents someone from doing something, an act of God, yes, then it's usually written into the legal agreement. So the basic rule is, if it's in the contract, it's force majeure. If it's not, we're talking frustration. So at common law, the effect of frustration is to discharge the parties from further performance of their obligations. But even though it has the effect of automatically terminating the contract, the rights and obligations that had accrued prior to the date of frustration remain enforceable. So the key areas here, make sure that you have a clear idea of what constitutes a frustrating event. It's got to be unforeseen. It's got to be outside the control of the parties. It must fundamentally change the environment in which the contract was supposed to operate. And a frustrating event might have the effect of making it impossible to carry out the obligations, or it may allow those obligations to continue, but deprive them of any real meaning or benefit. Now that seems extraordinarily broad. And you'd think, if you look at that in its broader sense, you might think it's relatively easy to avoid contractual obligations by simply alleging frustration, but it's not the case. When a court or a tribunal concludes that a contract has been frustrated, that is what we say a conclusion of law. And this is because it involves a consideration of the terms of the contract, and that's always a legal issue. But to determine this as a question of law, this is where it gets a bit tricky, the court or the tribunal must consider the evidence and must make findings on that evidence. So ultimately, it involves questions of both law and fact, where the court will, before arriving at a question of law to determine whether the contract has been frustrated or not, make specific findings of fact, upon which the court relies in then leading to its legal conclusion. Now, we do see that a lot, and when you're answering a legal problem, do bear in mind this distinction between law and fact. Sometimes students who aren't performing terribly well mix it all in together, but you'll often see this in a judgment. either oral or in writing, that the court will provide some overview of the facts. It might, and this is sort of Iraq methodology, it might provide some overview of the rules. It might then, in the case of applying the facts, say, the court makes the following findings of fact, A, B, C, D, and given those findings, here is how the court is going to apply the law. But they keep them quite separate, so it's very clear. This is a finding of fact. It leads into the findings of law, but think about that when you're arguing a case or writing an answer. So in your notes, you'll see that there are some key terms. Frustration is obviously very important, but there's some other terms you need to be aware of and use. Restitution and total failure of consideration is another one. On that latter topic of total failure of consideration, the leading case is David Security Proprietary Limited against Commonwealth Bank of Australia. It's 1992 175 CLR 353. So this relates to restitution, this case. In David Securities and the Commonwealth, the High Court developed the law of restitution in Australia. So restitution is an equitable remedy, and it usually involves payment of money. And when we talk about an order of restitution, what we're really doing is seeking to restore the parties to the position they were or they would have been in, but for the frustrating event. Now, you can see, if you're really thinking about that carefully, that restitution is quite different to the remedies for vitiating factors that we talked about early in the unit. I know it's only a small group, but can anyone see the basic difference in legal logic between the remedies that are available where there was the finding of a vitiating factor and the remedy that's available through restitution where there is a total failure of consideration? Any thoughts? I'm being difficult, aren't I? And probably obscure. What I'd suggest to you here is what's important is basic remedy. And where we had vitiating facts, for example, vitiating factors, the aim of the court is basically to put, that's it, Stephen's got it. Restoring the parties back to where they were at the start of the contract rather than at the time. So yes, when we're talking about restitution, what we're talking about is something that is in a way forward thinking. We're looking to restore the parties to a position they would have been, but for the frustrating event, as opposed to taking them back to the original position. So the key case here is David Securities in the Commonwealth. It was 1992 in the High Court. Now, the High Court developed this law of restitution in Australia. The old rule, which precluded the recovery of money paid under a mistake of law, is, as a result of this case, no longer part of Australian law, and the court decided that payments made under a mistake of law should be prima facie recoverable in the same way as payments made under a mistake of fact. And the High Court produced a structure for approaching unjust enrichment cases as a result. The court provided some guidance on how to deal with restitution and claims, whether it was based on a mistake or not, and that the law should recognise a defence of change of position to ensure that enrichment of a recipient is prevented only in circumstances where it would be unjust. So I know we're dealing with a few different concepts here, but where we have a frustrating event, it has certain legal implications. Where we have a situation where there is some basic mistake of law or fact, then we introduce areas dealing with restitution. We introduce areas dealing with unjust enrichment. And sometimes these things can look very similar. So my advice is, in preparing for any problem that you might get in this area of practice or this area of law, Try to have a clear understanding of the threshold questions, have some authority for that so that you can branch off in the correct manner. Because it is really disappointing to read an excellent question or answer to a problem, which is based on taking the wrong branch, fork in the road, as it were, at the start. Now, I mentioned Cadelpha construction as being a leading case in relation to frustration. So what happened in that case was Cadelpha contracted with New South Wales State Rail Authority to undertake some excavation work. They had to complete the work by a certain time, and both parties acknowledged and understood that to complete the work, it would require Cadelpha to have workers on site 3 shifts a day, 6 days a week, basically working around the clock. That was the common expectation. It couldn't be done unless Cadelpha wanted to do that. Now, an injunction was brought preventing Cadelpha from continuing to work around the clock. The litigant in that case brought an injunction successfully saying Cadelpha must stop because of noise and vibration caused by the work. So where does that leave Cadelpha and the New South Wales State Authority? Now, here's what's interesting. Both parties obtained legal advice that such an injunction could not be obtained. In other words, they'd thought about this before they came to the agreement to work around the clock. Both parties didn't think that someone seeking the injunction could succeed. They were surprised, of course, because that party was successful. Now, as between the dispute of Cadelpha and the State Rail Authority, the court held that there was, in this instance, an external event that occurred that would prevent Cadelpha from completing its obligations, and it was through no fault of its own. And it was through no fault of its own because there was the common expectation of both parties to the contract. So the court came up with the basic test. Have a look at that case, identify the basic test, and it's along these lines that frustration occurs whenever the law recognises that without the fault of either party, a contractual obligation has become incapable of being performed because the circumstances in which performance is called for would render the thing radically different from that which was undertaken by the contract. And the phrase, the thing radically different, is fundamental in any arguments around this case. So let's look at Cadelpha then. The due date where the company could perform work 24 hours a day simply couldn't occur once the workday was reduced to 18 days, 18 hours per day as a result of that injunction. The court said it wasn't their fault, it wasn't the fault of either party. It was clear that the contractual obligation could now not be performed, sort of like the concept of force majeure, and the obligation must be incapable of being performed because there'd been a change in circumstances, and in this case they described the change as a radical change. So that's the wording that we tend to use now in frustration contracts. Now, a word on absolute contracts. Sometimes a contract is absolute in that it's either done or it's not done. We don't care. Sort of frustration concepts don't apply. Now, this is a little bit like a solicitor's undertaking. I don't know if you've had any dealings with this, but one of the key tenets of practicing in law as a solicitor in Queensland is the role that undertakings play. There's some great material on this on the Queensland Law Society Ethics Centre website, but it works like this. If a solicitor provides an undertaking, then there are no excuses. If it doesn't happen, the solicitor is going to be held liable personally and may be prosecuted. It doesn't matter that their client, for example, let them down. So solicitors need to be absolutely clear that they give an undertaking, especially to a court, and there are no ifs or buts or maybes. That's it, you're liable. It's an absolute liability. It's an absolute contract, if you like. So a party may make an absolute promise to perform or be found to have taken the risk of such eventuality. It's like the solicitor's undertaking. The absence of an intervening event does not diminish the force of the undertaking, does not diminish the force of the obligations contained in an absolute contract. Natalie says, hard to prove if verbal. Yeah, that's true. If you receive an undertaking from an opponent, standard practice is you immediately write back and say, I note your undertaking given today at 4:33 that you will do this and this. Please contact me immediately. If you disagree, at least it sets up some evidentiary situation. So a distinction then needs to be drawn between absolute obligations and those that are conditional or dependent obligations on another. And if there's an absolute obligation, the promisor needs to perform. And if it's physically possible or even not, then that's too bad. For example, McRae and Commonwealth Disposals Commission, there was an implied warranty as to the existence of subject matter. It didn't matter that it wasn't there. There was an absolute liability on the Commonwealth in that case. Now, another thing that you might consider in terms of frustration is the timing of when the event might occur. That can be critical. And in that sense, there may be at first glance some similarities between two legal concepts. One is frustration, that we're dealing with now, and the other is one we dealt with a few weeks ago called common mistake. So you need to be clear on this and again argue correctly based on frustration or common mistake. They don't sit well together. They are closely related, but there are differences. Now, mistake relates to circumstances at the time of the agreement, but frustration and a frustrating event occurs as a future circumstance. That's the first dead giveaway between frustration and common mistake. Mistake renders contracts void or voidable, but with frustration, the contract is discharged as to the future only, and that happens automatically. Have a look at Taylor and Caldwell. This is a really well-known and well-cited case in this area of practice. It's an old one, 1863, 122 All England Reports, that's ER 309. It related to a lease of a music hall. It burnt down. It was an accident. It wasn't the fault of any of the parties. The court said the contract has been frustrated. But frustration would not occur if it was the fault of one of the parties. So there's a grey area. And frustration would not occur if one party had agreed, either expressly or impliedly, to bear the risk of destruction. And we see that in conveyancing. In conveyancing contracts, typically there will be a clause to say the risk is with the buyer or the risk is with the seller. Typically, the risk remains with the buyer. What that means is if you sign to buy a house and the house is destroyed by fire between the contract and before you've paid for it, too bad. It's not a frustrating event because the buyer had expressly agreed to bear the risk of destruction. Now that's a huge rider on frustration. So if you're going to answer a frustration problem and it's silent in the question as to whether the parties have agreed expressly or impliedly to bear the risk of destruction, you're going to be remiss if you don't state that as an assumption you make, because it's a key one. Do you understand? This is where my checklist, toolkit, flowchart, whatever works for you is really important, so you don't fall into these obvious errors. What we don't want is, in one of the answers, when corrected, to say, oh, of course, I'm sorry, I forgot that. Have a look at the Sale of Goods Act. Section 10 deals with an issue around how the common law position can be altered by statute. Section 10 of the Sale of Goods Act says, where there's an agreement to sell specific goods and subsequently the goods without any fault on part of the seller or the buyer perish, before the risk passes to the buyer, the agreement is avoided. So a supplier who's agreed to supply goods of a generic nature cannot rely on frustration because they cannot source the goods from an intended source. The situation would be different if the intended source was actually identified. So Section 10 talks about an agreement to sell specific goods, not general goods or goods of a general description. Death or incapacity of a party is also an area where frustration might be considered. Now, the basic rule is this: if performance of a contract has a personal element, then the death of the party to that contract may frustrate performance of the contract. So Morgan and Mansur, 1948, 1 King Bench 184 is a good example. Mansur was a performer. Morgan was his agent. Morgan used his best efforts to secure work for Mansur. Mansur was to make himself available to do the work and to pay Morgan a share. But Mansur was conscripted to war, couldn't fulfill the contract, and the contract was therefore terminated by frustration. So the mere death of a party may or may not be enough to frustrate the contract, depends on the extent that personal service is required. And the failure must be the basis of the contract. Have a look at Krill and Henry. It's 1903 to King's Bench 740 rather. Henry hired a flat from Krill, and the purpose of the hire was this: that is to see the coronation parade of King Edward VII. Now, both parties knew that was the only reason for the contract. King Edward became ill, the coronation parade was cancelled, the contract was based on the existence of the parade, so in that instance, given the common element, the contract was held to be frustrated. Now, sometimes, and this is a really good area of, for interesting area, the contemplated method of performance may not be possible. And here's where we get into this area of determining whether or not the contract is frustrated, and it relates to whether the change is sufficiently radical or substantial to warrant one of the parties successfully arguing frustration. So if the contract required performance in a certain way and the method of performance is not possible, the contract might be frustrated. But only if the change in performance is radical or substantial. A good case is the Eugenia case, Ocean Tramp Tankers against Sofrac. The Eugenia is the ship. 1964, 2 Queen's Bench 226. What happened is the Suez Canal was closed in the 50s and vessels then had to travel round the Cape of Good Hope, and the change of performance, although very onerous, was regarded by the courts as not sufficiently material to allow for a successful frustration argument. Now, delay is another issue. There might be a delay. Question is, does that delay cause a frustration of the contract? It depends on the facts. So what you can see is the common theme here with all of this, isn't there? A key question is to ask whether the parties had agreed to the risk of the frustrating event. And for example, if the party said, we will deliver these goods, they might have intended to go through the Suez Canal, but because they couldn't, ultimately the courts will say, well, you're the one that did bear the risk of that. And the frustrating event must be assessed at the time it occurs. If a court decides that a reasonable person would have drawn the inference of frustration, then the contract is discharged, even though it subsequently transpires that the frustrating delay would not have occurred. So the onus then, if you've got an argument around frustration, is on the party that alleges frustration was self-induced to prove the case. And when you're thinking about this area of practice, also be very clear on the effects of frustration and when the parties are discharged from their obligations and what are the ramifications of that. Now, that's all I propose to talk about on frustration. We have a general question that I'll come to shortly, but are there any questions about frustration which will essentially take us to the end of the week 8 material, meaning we start with week 9 material to do with remedies and damages next week. No questions? All right. Now, question from Natalie. What is the exam structure? Essay style questions. I have the dates, but not assess the setup. Now, this is something that I provide more detail on in week 10, which is next week, but I will give you an indication from memory, the paper, and I wrote the paper some time ago, but from memory, there is a problem question and 2 essay style questions. And as I recall, and I think the essay style questions are worth maybe 10 marks each, and the problem is worth, I think, 30 marks for a total of 50. And we've had 20 on the first assessment, 30 on the second assessment, 50 in the final exam. So problem question will be, I think, 30% of the overall. Okay. Any questions, comments? All good. Thank you very much for your attendance this evening, and we'll look forward to seeing you next week when we start the week 9 material. All the best. Bye then.